You know, your relationship with your doctor is about to change in a really big way. And it has nothing to do with medicine. It's all about your data. India's new Digital Personal Data Protection Act is here, and it's designed to do one simple thing: put you back in control of your most sensitive information. And this quote right here, it really gets to the heart of the matter. Behind every single lab report, every x-ray, every line of data, there's a real person. A person with hopes, with anxieties, and with a fundamental right to privacy. We're not just talking about ones and zeros here. We're talking about human dignity. So you have to ask yourself, as literally everything from our prescriptions to our private consultation notes goes digital, who is actually protecting all of it? For a long time, the answer to that question was, well, pretty unclear. But now, a new law is here to give a very, very specific answer. All right, let's start by digging into what this data really represents. Because it's not just some file sitting on a hospital server, it is the entire story of your health. You know, this is a massive shift in perspective. Your medical data isn't some commodity for a hospital to own or trade. The law now sees it as a direct extension of you, and it's governed by a relationship of trust with your healthcare provider. So, how is this new relationship actually enforced? Well, that's where the Digital Personal Data Protection Act, or DPDPA for short, comes into play. It establishes a whole new set of rules with two key players at the very center of it all. First up, there's you. The law gives you a new title, the data principal. And that's a really powerful term, isn't it? It establishes that you are the origin and the owner of your health story. You are the main character. And the other key player? That's the data fiduciary. Just think of them as a trustee or a custodian for your information. This is your hospital, your diagnostic lab, or that health app you have on your phone. They now have a legal duty, a fiduciary duty, to protect your data on your behalf. And this right here, this lays out the new power dynamic perfectly. It couldn't be clearer. You own the data. You give consent. You hold the rights. Your provider? They are simply the custodian, with a huge legal responsibility to protect it. That one distinction, it changes absolutely everything. So, how do you grant them permission to use your data? Through consent. But listen, the days of just ticking a tiny box next to some 50-page document you'll never ever read, those days are over. That old system meant people gave away all sorts of rights without even knowing it. Under the DPDPA, consent has to be free, specific to one purpose, and limited to only the data that's absolutely necessary. So a telemedicine app, for example, can't ask for access to your entire phone contact list just to give you a doctor's consultation anymore. But, okay, what about a life-or-death situation? A moment where getting consent is just impossible. Well, the law is pretty smart about this, and it has carved out some very specific exceptions for the greater good. So here's how it all breaks down. For your routine stuff, think telemedicine, regular lab tests, or sharing data with your insurer for a claim, your specific informed consent is mandatory. Every single time. But in a real medical emergency where there's an immediate threat to life, or during a major public health crisis like an epidemic, providers can go ahead and process data without your consent. And the logic is clear, right? In those critical moments, the law prioritizes saving lives and protecting the public. Now the law gets even stricter, even more protective when it comes to the most vulnerable among us, children. It basically builds a fortress around their data. The rule is simple and it is absolute. For anyone under the age of 18, their data cannot be processed without the verifiable consent of a parent or guardian. And that word, verifiable, is key. It means the provider has to make a real effort to confirm the adult's identity, maybe with a government ID or some kind of digital confirmation. And the protections go even further. There's a complete ban on any data processing that could possibly harm a child. That means no tracking their online behavior and absolutely no targeted advertising. There's one very narrow exception. A doctor can provide necessary health services to a child without parental consent, but it is strictly limited to what's essential for that child's immediate health and well-being. So, with all these new rights for you and your kids, what are the new obligations for your healthcare providers? What do they have to do now? This one is huge. If your data is ever compromised in a breach, the hospital or lab can't just hide it or sweep it under the rug. They are now legally required to inform both you and the new Data Protection Board immediately, or as the law puts it, without delay.
And this timeline just shows how serious this requirement is. An initial notice has to go out the moment a breach is detected, and a full, detailed report has to be filed with the board within 72 hours. This ensures total transparency and a really rapid response to protect you.
Remember how privacy notices used to be? They were always buried deep in the fine print of an admission form or hidden in some vague terms and conditions link that nobody ever clicked. Let's be honest, they were designed not to be read. Well, that's all gone now. The new rule is a complete revolution in transparency. The privacy notice must be a separate, standalone document. It has to spell out exactly what data is being collected and why, in plain, simple language. And this part is critical. It has to be given to you before a single piece of your information is collected. So, what does this all add up to? What does it all mean? It means we're moving toward a healthcare system built on a whole new foundation of trust, and this time it's actually backed by the force of law. You are now officially empowered with a clear set of rights. You have the right to see your data, to correct any mistakes, to withdraw your consent at any time, and even to have your data erased when it's no longer needed for its original purpose. This puts you, finally, in the driver's seat. And if you feel like your rights have been violated, you can file a grievance directly with your provider. They have a maximum of 90 days to resolve your issue. If they don't, or you're not satisfied, you can then escalate it to the National Data Protection Board. I think this quote just captures the soul of this new law perfectly. Health data isn't some resource to be mined and exploited for profit. No, it's vital, it's precious, and it requires careful, ethical stewardship. Ultimately, this law gives you the tools and the rights to take charge of your personal health story. The power is now officially in your hands. So the only real question left is, are you ready to use it?